All right, so employment law, chapter 18. These are some of the objectives, more on the next slide from the chapter. We talk about employment at will, talk about federal statutes are related to employment. Here's an example, the FMLA. Talk about that. We talk about immigration slightly. That's one of the changes in this edition of the textbook, to charge you more money. But also, seriously, because immigration law is becoming more important now that states are trying to pass laws related to immigration as well. And then we'll talk about Title VII, the Civil Rights Act. You may have heard of Title VII before. So, employment at will. How many of you are at-will employees? Yeah, some of you know for sure. You were told that, right? First day on the job, like, don't forget you're an at-will employee. Anybody a contract employee? I am. In my job here, I have a contract. And, basically, if you're not a contract employee, then you're at will. Yeah. You're a union. Yes, I am a union employee, and I have a faculty contract. You're subject to some type of agreement in terms of your employment.
So, if you're a member of a union as an employee, are you an at-will employee?
Usually not. Like in my situation, I'm part of the faculty association, and we have an employment agreement as to how we'll do our job and what our employer is required to do. It's written. In fact, it's online. If you go to grccfaculty.com, you can learn all about my contract, find out whether I'm adhering to it or not. But at will theoretically means you could quit at any time for any reason, and your employer could fire you at any time for any reason. Now, as it says in the second bullet, and you should have got out from the reading, it's still true today that you can quit any time for any reason if you don't have a contract. If you quit and you have a contract, you might be breaching the contract. But still, even if you have a contract, they can't force you to do labor unless you're in prison. Right? I mean, the idea that you would be forced to do a job is involuntary servitude. But basically, if you're employed at will, you could decide not to work there anymore, and you can have whatever reason you want. On the employer end, probably more limited in terms of what they could fire you for. Not probably, it is more limited in terms of state and federal law and some case law exceptions, which we'll get to. And here we are. So it says that the employer would not have liability if they got rid of you because it's at their will. However, states have recognized a number of judicial exceptions to the at-will employment. I'm guessing they're on the next slide. Here are the three big ones. Exceptions to at-will employment, the idea that employers could get rid of you at any time for any reason. The contract exception, tort exception, and public policy exception. Now, it might sound kind of weird because I just defined at-will employment as not having a contract, and then the first exception is contract. But what we're talking about here is even though you don't have a express contract, one might be implied. In other words, if you get fired, you might make the argument, well, by firing me, you breach an implied contract. What was the example they used in the chapter? Does anybody remember that from your reading of the chapter? 18.
Goldfinch Incorporated.
What if, no, we haven't got to FMLA yet. But that shows that you read further in the chapter. What was that case about?
Goldfinch induces a prospective employee to leave a lucrative job.
That was not what I was thinking of. But that's a good case. So under exceptions to at-will employment,
Sorry, BDI.
yes, that one. What was that one about?
It says workers will be dismissed only for good cause.
Right.
Employee reasonably expects.
What page is that on?
515.
So 515, example 18.1, just for purposes of our recording here. Don't get that backwards. 515, if I get it, it's the same either way. Yeah, an employment manual, although not a contract of employment, might imply your employer has to follow certain steps before they fire you. Anybody work someplace where they say, first time you get an oral warning, second time you get written up, next time don't bother coming back to work? So if they have a manual or some policy in place that says that, then that should be how they treat you. And also, if they treat other employees like that, you notice other people around you getting oral warnings and written up. What if it comes to you and they just go, you're ugly, you're fired? Right? I mean, I'm not trying to look at anybody in particular when I say that. I'm just, what if they look at me? You have an ugly bald head. Why'd you shave your hair off? You're fired. Right? Yes.
If you have those guidelines in place, are you as the employer free to break those? Are you say there's
Well, this is the argument. Why have guidelines or policies? And if you want to claim you can fire anybody at any time for any reason, then don't put a policy in place that says you have to do these things before you do.
Right. But I'm saying you have, like, as an example, if you had 30 employees and one of them, you, for some reason, as an employer, have given 3 or 4 final warnings, but any of the others, or some of the others, have been canned.
Right.
3.
Right.
Do they have, if they were to catch wind of that, would they have any way of getting back?
Well, this is the theory.
Okay.
This is a theory that you, or let's say someone else, they get fired, and the employer says whatever reason they want to for why they got fired. Then this theory is that employee says, look, your policy says I was supposed to get all these warnings. And in fact, implied in fact, here's an employee who didn't get fired. And you followed this process before you did, but you didn't with me. It was implied that you should treat me that way. So that's the theory. So I'm not saying just, it's an automatic wrongful discharge if that were to occur, but you can make a case that the policy says something different than what the employer actually did.
You got an argument.
Yes. Yeah.
I've seen in a number of handbooks though, they have the policies and things to get fired, write-ups and things like that. But at the same time, they also put in there, but we reserve to not follow these procedures and discharge at any time.
Definitely. Yeah. That's to account for this. One of the things you're going to say is, you're an at-will employee.
Right.
By putting this policy in place, we are not claiming any type of implied contract is in place. And we could choose to do what we want. It's our prerogative to give you warnings. It's our prerogative not to and consider your offense serious enough just to fire you on the spot. But I'm saying people have had some success at saying your policy doesn't read like that. It says you will do these things before we dismiss you. All right. Or something that somebody orally agrees, even though there's not a written contract. Or a tort, the second one up there. I like to think of this more as it's not what you were fired for, but how you're fired. It's done in a way that's tortious. So let's say you're all my employees. Wouldn't that be fun? In addition to me teaching you, then when you leave here and go to your job, it's me again. So let's say I suspect one of you has stolen something. What would be a good way to handle that and a bad way?
bad way would be to walk up to a person and accuse them or go through their
Right, like, thank you coming for my meeting today. I think you stole something from me. You're fired. Well, then later it turns out you didn't, and I fired you wrongfully. What's it called when I intentionally accuse you something that's harmful to your good reputation?
Defamation.
Yeah, it's not true. So that's tortious in the way I did it.
Could it be tortious just in the way of calling someone out in public and around everyone else, regardless if it's true or not? Could that come back on you?
Well, the question is it a tort? I mentioned defamation as one example, as the slide does, but there are other things. Generally, is it intentional infliction of emotional distress to be fired? You might, as a person being fired, you might claim, yes, I was distraught over being fired. But the question is, would the circumstances be sufficient for the court to say, yes, that was the way you did that was so outrageous that it arose to the level of being tortious. Like I invite you into my office, we sit down, I say, this is the problems I have with your performance, I'm going to have to let you go. And you're like, you start crying, you break out in hives, you leave, you want to kill yourself. I mean, these things could really happen, but that doesn't mean objectively that I've intentionally inflicted emotional distress on you. Now, I suppose there are other ways I could fire you where, a court could reasonably determine that's just tortious. I'm trying to think. I don't know. What if I body slam you? I probably wouldn't do it to you. You're kind of bigger than me. But generally, it's the way that I do it or what I do. It could be tortious. You're looking back. Yeah. He's bigger. All right. Public policy. So this is always when you see the public policy exception. That means it may not necessarily be covered by statute, but the courts would just frown on it because that would be bad public policy. Now, the example up there mentions whistleblowing. There are statutes about that. Basically to encourage employees to report that their employers are doing unlawful activities, there's some statutory protection for that. There was this case where a pilot kept telling his employer, the aircraft that you're having us fly are unsafe. And the employer kept flying them, and then one of the airplanes crashed and killed people. And he went on a morning news show, the Today Show or some show. I use the term news loosely, but and said, like I was sitting in my dentist chair the other day, and there was some news show on, and it was not doing what I would call news, but anyway, I think it was the Halloween costume judging edition. But anyway, so during one of those segments, the guy comes on and he says, yes, I work for this airline. I warned them. They didn't listen. Now people have died. They really need to not fly this airplane and do these things. So he goes back to work. And they want to subject him to an extensive search. What do you know about pilots and how they go through airport security?
They don't.
They just,
Yeah.
good morning, how's it going? Come on through, right? Well, they didn't do that with him. And he refused to be subjected to the search, and they said, well, our policy is if we want to search you, we can. You're not cooperating with us, you're fired. He argued that it was in retaliation for what he had just done and won in court. Now, I don't know if I want to go back and work for a place like that. Whistleblowing says your job's protected. That means you go back to where you're at, and they're not very happy with you. But I guess it does
But you're not going to be hireable somewhere else either, so.
Yeah, if you're on the news, and I guess it depends on the nature of the job.
If an airline, if you're trying to protect passengers, they're probably going to be, other airlines are probably going to be okay with you,
Yeah, they might want you to have handled it differently. But, in his case, his argument was, I tried. I mean, I tried to handle it differently. I went to you, I mentioned you several times, and I mean, what the reverse of that is, what if you never say anything and then people die? I mean, it's so, yeah, they might consider that a good thing that he actually did. But yeah, I mean, overall, I think in the corporate culture, we don't like people coming out and saying our employer's bad and doing something illegal. But, you know, there's situations where it's, you know, it needs to be done because it's illegal, whatever is happening. Basically, the theory is, at the end, the bottom bullet here, that you are discharged and your employer is claiming they have a right to discharge because you're only at their will, but the way that it was done was wrongful under these different theories. Even the Exxon Valdez case, they're still cleaning that up. And, you know, there was an argument that the person who was piloting the ship was wrongfully discharged. Yeah, that was the argument, was that, you know, hey, you didn't have a right because there isn't a law that says you can't drive oil tankers while under the influence. And the response was, it was true. I mean, they keep coming up with new statutes because people come up with new things to do that aren't covered by a statute. Like, who would have thought driving around and be oil tanker drunk? But you know, the argument was, well, yeah, but it's still bad public policy. I mean, if we let this person stay employed, then it sends a message that you can do this. Yeah. And I suspect that did and does happen. Like, you always hear cases where, like, big ship, huge bridge, they run into it. Could you not see that? You know, I know there are other factors that come into play, but trains that wreck, buses that get into accidents, you know, I think there's some of that is going on. There was a case not too long ago, guy was texting while driving an Amtrak and crashed the train.
A friend of mine's husband's a truck driver, and the guy from the place that pulls you over is like ELAT or something. He told him about a guy they had just pulled over that was drinking beer and driving a semi. He had a 12-pack.
Right, the old. It's not illegal to drink and drive. It's just illegal to drive drunk, you know. But right, you know, it's okay. I'm just in my cab and
Wow.
right. Yeah, you know, and
It was empty.
I'm not condoning that. I don't want anybody who's listening to this recording get the impression that I'm condoning that. I'm not. You know, like texting and driving, right? I still see it. Like, I drive and I look and I still see people driving, texting. Truck drivers do that too.
You just can't see them.
Right, they're up higher, right?
Just because the steering wheel's huge doesn't mean
Right.
you can put stuff in it.
Your computer, your lunch, your
The city bus driver
Yeah.
reading and driving.
yeah.
I like watching
If you're out there listening, city bus drivers, stop. What?
I like watching the videos like on YouTube where the truck like slams into the bridge and it like floats back.
You like watching those?
Yeah.
Sadistic.
Right.
I mean, there's been some serious cases, like people have been in accidents caused by trucks that have went across highways, and the reason's been because they were texting or drinking or not, or sleeping. Sleeping and driving don't mix. See the things you learn in this class. Child labor, maybe that's bring back some memories for some of you, although that looks like that was back when the act was passed. Anybody grow up on a farm where you got worked no matter how old you were? Yeah, my parents, you know, family-owned business, and they were like, child labor, meh.
Right.
Right. Who cares? Right. I mean, there are some statutory exceptions, but generally, you can see the law's been around since I was a teenager. You know, it's supposed to prohibit oppressive child labor practices. You probably have had some experience of that if you worked as a minor. What kind of things couldn't you do as a minor?
Work
operating.
Yeah, certain number of hours, what type of machinery you could work, like things that might cut
The
parts
slicers
off,
and
and
the
right, yeah,
knives, you couldn't work till you're 18.
lots of if you can't use certain power tools and be in my
Service, if you're not over 18, you can't serve liquor.
right, what you can serve, where you can work. Somebody was mentioning to me last class, like not working in a gas station, not because there's a law prohibiting you from it, but it's kind of hard to sell cigarettes and alcohol and all those things without being old enough. Yeah.
Can't work after 10
For the
p.m.
haunted houses, you have to be 18.
Oh, really?
They made an exception for my brother who's 17 because he's been in Boy Scouts and he worked in haunted houses, but they said like on the contract you have to be 18.
Oh, I wonder if that's statutory, if that's just a contractual thing.
Yeah, I don't think that that's actually like a law because I know like at the haunt, like there are people that are underage.
Dead people or
Yes.
zombies? Yeah.
If your employer has it posted, you must be 18, and you use it and you're under 18, that takes the employer off the hook, or are they still liable?
Well, generally, posting things doesn't mean you're, unless there's a statute that says you're required to post something or not post something. A posting doesn't necessarily say you're not subject to whatever statutes are out there. And if that's what you're saying, like by putting something up, you get to circumvent some statute.
Meaning, example, like, when I was a therapist, there's a young lady, they have, the machine that you put the pop cans in.
Okay, yes.
And
right.
so she was behind it trying to unstick it, but
right.
the machine, I guess, said
yes.
you have to be 18.
Yeah.
She stuck her hand in it, it got caught, and it ran her whole arm through, crushed all of her bones.
Oh,
and then
man.
it had to crush it again to get her arm back out of the machine. So, of course, she has pins and everything. My question was, so...
Right, by putting a sign that says, hey, you got to be 18, right. Well, I think the employer, it sounds like, was trying to do their part by saying, there's certain jobs you can and can't do. If we catch you doing that, you're fired. Well, you can't always catch your employees before they do something like that. It's kind of strange because in the last class there was a guy who works in that environment, and he was talking about how, gosh, who would actually stick their hand in there?
You'd be amazed.
So.
Oh, it's right there. I can reach it, and it's got you.
Yeah, maybe you have a disorder where you compulsively want to try to see if I know the sign says it might eat my arm, but let's see if it really can.
Oh, it's not.
Will it really do?
They're far enough to do any damage, and it will only take me a second. And without even thinking, people, I'm at work. I got to get this machine going again. Right.
Well, that's true. I mean, regardless of age, there are people who are like, I know there's supposed to be a safety guard here, or I'm supposed to. Like when we were talking about, I don't know if we talked about the product liability, it was a case where the employees had engineered a brace that actually you had to have two hands on the press to turn the press on or off, and that was so that you didn't have one hand in the press while you were doing whatever. And the employees had, without the employer's knowledge, well, they said, retrofitted it so that you could do it with one, so you could be faster, get the job done, meet the quota, whatever. And sure enough, somebody put their hand in there and triggered it and smashed it. Yeah, well, or get to OSHA. I mean, there's multiple ramifications to this. But yeah, back to your question. I mean, one thing you can do is just not hire minors because you're doing that kind of work. Another is to say to them, you can only work in these, I think of McDonald's, there's what jobs can you do while you're there? How many breaks do you have to take? What hours can you work? I mean, it would be hard to find.
All right. Now, like for her, she can't go back to work for probably forever. But so is her employer responsible for her medical bills because it happened at the job?
Well, we'll talk about workers' compensation, and there are situations where employees have been able to recover due to their own negligence. They've done something on the job that was an accident. That becomes one of the issues. Was it something intentional? Right? Like when presented with a sign, don't do this. You're an employee, we've told you you're not a sufficient age to even be messing with us, and you do it. should it be covered? Question or just kind of stretch? Yeah, it's good to stretch. Wage and hour laws, without going into detail of each act, you probably have had some familiarity. We were talking about this last class up here on the board. Minimum wage. I was pointing out that I believe there is a different minimum wage for minors, because we were just talking about minors.
Yeah.
Somebody said 80%. I computed that. I don't know if that's accurate
Minimum
or not.
wage is $7.40.
740 now? So yeah, there's some kind of sliding scale. It's been going up. Somebody Google it. See, that's why you don't Google things. I Google everything, by the way. So what would somebody who wants to could look up what is the minimum wage for minors?
$6.15.
I thought it was closer to.
Yeah, because
If you're under 18, it's $1 less.
Pretty sure it's about $1 less.
So maybe around 640. Somebody probably could look it up.
$2.85 if you're a waitress.
Yeah, different laws are relating to, whether you're getting tips, what the source of your income.
$265.
Yeah, it's 265.
Yeah, but my
Yeah, I'll write another one. I'll write another number up here, 265. So,
And doesn't it differ between states?
yes, because while this law up here addresses minimum wage, the law that we're talking about distinguishes is state law. There are state laws related to what the minimum wage is. In fact, even within municipalities, like when I was in Kalamazoo was trying to bring a younger workforce into that area because no one wants to live and work in Kalamazoo. So they were actually saying, we'll pay you more of a minimum wage, if that makes sense. Like come here, you might make minimum wage here, somewhere else of this, but we'll pay you more than the statutory requirement. So yeah, it does differ. And there are some restrictions on how many hours you can make, regardless of age, how many hours you can make wage-based or hourly-based employees work.
Who determines the overtime exemptions? Is that a federal mandate or?
There, on all of these laws, there are both federal and state regulations, and it's hard to get into the state ones because they do differ quite a bit. But most of these laws, just generally talking about them, are related to how many hours you can have an hourly employee working in a week without paying them overtime, what the exceptions are. One of the common ones is, if you're an administrative executive type person, paid on a salary, not falling within that. But that, that's a common question people have. Not that I can't do certain types of jobs, but that I'm in a type of job that is hourly. Can my employer make me work so many hours per day? Usually, yes. When does the overtime kick in? And that's you've got to look at the statute. And then layoffs. Not in the older edition of the textbook, in the newer edition. So areas like immigration law, layoffs, they've added to the textbook because they are becoming more prevalent, right? I imagine some of you in class here are here because you were laid off or became unemployed from working somewhere. And so there are some efforts to try to have employers be accountable for the results of their layoff in terms of how they do those layoffs, what type of notice that they give to their employees. In fact, this is one of the first slides that starts to address what size employers we're talking about. This is kind of on the high end. Like if you're going to let go a lot of employees, then there's certain statutory requirements you have to meet when you do that. And then we'll go to the low end. We'll be talking about situations where if you have 50 or more employees. How many employers do you think have less than 50 employees?
A lot.
Most. I mean, a lot of people think companies are big, they have lots of employees, but most businesses in the United States still are smaller. But if you're a bigger corporation, there's more law. And the theory is that if you're small enough, you won't have all this red tape. But there's still plenty of law to go around. And just because you don't have enough employees doesn't mean you can be unsafe or something. Like when we talk about OSHA, it has requirements in terms of reporting, but that doesn't mean you still don't have to comply with statutes related to safety. So now we start to get into the particulars. I was just mentioning 50 employees. FMLA, a lot of people think of this as the Pregnancy Act, but that's not the case. That's one example, which, by the way, never tell a pregnant woman that she suffers from a serious medical condition. I can tell you from experience, she doesn't like to hear that. But my point is that serious medical condition could certainly be a variety of different things, and it doesn't have to be you. It could be you're taking care of someone else, yeah.
When my grandma was visiting us, she broke her foot in like 3 places. So my mom took time out for this to take care of her.
Yes, there's an example. It could be a family member. It could be somebody you're responsible for taking care of or become responsible for taking care of. Yeah.
Adoption is covered under.
Yeah. So, I said pregnancy. Well, there's other ways you could get children. And so you really have to look at the provisions of the statute. And this is not the statute. This is kind of the author's summary of what's covered. But just looking at this, over 50 employees, unpaid leave. I mean, a lot of people think, oh, I get leave if I fall under the act. Okay, maybe you do, but you may not get paid for it. I say may not because in some cases employers do agree to pay during that. I took FMLA once when we had our first child. Everything's crazy when you have your first child. You're all nervous and everything. Now it's just like, whatever. Let them play in the street. But, with the first one, so I took time off from my employer under FMLA, not my current employer, my past employer. And I was able to use all my leave, accumulated vacation, sick, whatever, for that. So I got paid the whole time I was on leave. And then my wife said, go back to work. It's like taking care of 2 kids. So we talked a lot about how you can get it, but there's the other part of the act, which is just as important, is getting back to your job. So, if you have to take time off to take care of grandma or your child or an adoption or something, when you go back, you should be able to get your same job back or a similar job. There's been lots of litigation about that one too. I mean, at a time where you're downsizing and you have to make changes because that key employee is gone or whatever, are you able to offer the same job or a similar job? Sometimes the debate is whether what you came back to is similar or not. Yeah.
Now, people can use FMLA for themselves too, right?
Yes, right. That's when I started out saying the Pregnancy Act. I mean, you could say, I need time off, right? So, yes, but separate from that, it might be some serious medical condition that you suffer from.
Does it have to be a condition? Can you just take?
Just take it. Just take time off.
You want to go back to school or whatever.
You have to. It's a medical leave act, so you have to meet the requirements of the statute. Now, this is a broad brush over this. There are lots of employer policies around this. So when the statute uses certain words like a serious medical condition, well, employer might have some language around what they believe that is, or how much time, or things like that. So you got to look at all of the language of the statute to find out if it's covered. But just, I want to take time off to discover myself and Yeah. Right. Yes. And maybe it's all in the head. I don't mean to make light of that. I mean, that could be a serious condition also. All right. OSHA, you guys mentioned that. You guys have had experience with OSHA before? Yeah.
We even had rules on how we could mix the chemicals to clean the store.
Good idea to have rules around mixing chemicals. You mix them the wrong way?
Well, even if the rooms, we had to be in a separate room, and you
Right.
had to have special gloves on.
Yep.
And
Where you store chemicals, how you handle them, what equipment you have. There's, if you look around here, even on this floor, it refers you to the website to where you can find information about, what do they call those, material data safety sheets or something?
Yeah.
Go what chemicals we use in the workplace and, eye wash stations, what protective gear you have to have. This mentions OSHA. There's also my OSHA. I mean, there's regulation at the federal and the state level. The bottom bullet talks about reporting. So you may have had experience of this not just because somebody came in and inspected your workplace, but because there was an accident, somebody was injured, and in that case, reporting it or keeping records of your employee. Because it's important to track for trends. Like, it seems like a lot of people are getting injured. What's the reason for that? If you have 11 or more employees, then the law requires you to keep records. Now, am I saying that you don't that not to keep records if you're a smaller business? No. I mean, if you are an employer concerned about liability, then if you've got less than 11 employees and your employee injures himself, you're going to want to document that, get it taken care of. But this is a statutory mandate to keep certain records when something happens. All right, state workers' comp law. Notice I've been saying there's federal and state. There's federal and state law. Well, now this one is entitled state workers' comp law. Workers' comp law is at a state level. So where you go to get a remedy is determined by state statute. And because it's state law, it's not uniform. Like one state's laws is different than another. So the slide, and I will just talk generally about workers' comp law. Basically it's the requirement to seek compensation for injury from a fund versus suing your employer directly. I mean, typically if you get injured on the job and you think it's your employer's fault, you might want to sue them directly for it, but that may not build good relations at work. You go to court, see them at work, and then they may not like that too much. What's that? Hey, good seeing you in court this morning. Sorry I said those things about you, about being negligent and everything, but right. So the two big issues that you need to be concerned about, just for life, for the practical exercise coming up, and the final exam, are how you're injured and where. So generally, workers' comp law is to compensate you for accidental injury that occurs on the job. So you're not covered if you intentionally injure yourself, which we were talking about that earlier, what's considered intentional. And you're not covered when you injure yourself at home and then come to work and say, I'm injured. There are people who do that. They injure themselves on the weekend and then they come to work and say, oh, I hurt myself. So, but those are the two big issues of contention when somebody files a claim. Now, if you do sue your employer, you're out of luck for workers' comp. You need to pick a path. You shouldn't get both, right? When would it be likely that you would sue your employer directly? When you don't like them anymore, you don't plan on going back, right?
There is no work comp.
Right, there might be a situation that's not covered. Good. That might be your option. Right? Earlier, I'll get to you in a second. Earlier, we spent a lot of time distinguishing between employees and independent contractors. Here's yet another reason, right? Workers' comp covers workers. You're independently contracting. You could be in the same situation as an agent that a worker is and injure yourself. Yeah.
You said that you cannot sue and get workers' comp. Does that mean that you can't get money from both, or you could try and sue?
Well, what I'm not saying there's a statute that says you can never do one or the other. I'm saying that one defense to a workers' compensation claim is you've already recovered from us civilly.
Okay.
So the same claim that you're raising here was the subject of a lawsuit that you were compensated for. If it's workers' compensation, you should be compensated once. Now, back to what we were just saying, perhaps you have some injuries that you're claiming aren't covered by workers' comp, and your only avenue for those injuries is to sue the employer directly. But again, the reality is you don't always want to do that if you're still working there. Right? So, we've been talking about a number of avenues that, might be points of contention in terms of how you were injured. Let's say, for example, here's a scenario. You work for a cable company, right? And you're off-site somewhere, right? I mean, cable company, not all employees work at headquarters, right? They go out, they do work. So let's say an employer sends a couple employees out on a job at some remote location. That's still considered part of your employment, even though generally driving back and forth to your work is not. But if driving back and forth is your work, then yes. If going to some remote location to do part of your work, that would be considered part of your job. Subject to all the frolicking that we talked about earlier, right? One issue that come up, what if your coworker injures you, right? The company says, go out there and clear some trees to do whatever you need to do. Your coworker confuses trim limbs with trim your limbs or something, I don't know, and they accidentally cut you. Well, your employer might make the argument, it wasn't us, it was him, right, your coworker. But typically, workers' comp will cover that too. You're still a worker, you're still injured, it still occurred on the job. Just was your coworker that did it. That might be a good place to take notes here. I said it was a cable company. All right, so here's some different types of income security, just to kind of give you a broad overview of the different types of laws that try to protect different aspects of your income, from Social Security to welfare to Medicare based on age to pensions. These are all attempts to try to give you some income security. Got some slides coming up here talking about insurance in more detail. Certainly pensions, how they're funded, how they're protected has been a big topic in the news. Other sources of income security, unemployment insurance. So, and that's certainly been in the news. Lots of questions about will benefits be extended? How long will they be extended for? I am blessed to not have had to worry about that for a while. I've been employed here in one spot for 10 years. I'm happy about that. I did lose my job once. My mother fired me. Yeah.
Restaurant did you work at?
Kentucky Fried Chicken. And I just thought of it again because Thanksgiving is coming up. I'm not going over her house because she fired me. But when I went to claim unemployment, they said, no, your boss told you what to do and you didn't do it. So it wasn't intentional on your part. So, Mom, I'm still upset.
And how many years has it been?
Yeah, it's been a while. I started in high school, and I worked in college. I worked for a few years there, so if you knew when I was in high school, you'd know how long ago it was. Since I was a teenager in 1923. It was, yes.
Doubt that.
All right, COBRA, the arch enemy of G.I. Joe. Sorry. But also a cool Mustang. But also the Consolidated Omnibus Budget Reconciliation Act. See, COBRA sounds a lot cooler. I do. I memorize these dumb things, but you don't have to. But do remember, COBRA is a way of getting medical insurance after you leave employment, if you can afford it. It doesn't say that on the slide, but from my experience, and other people tell me the same thing, it's kind of difficult to afford insurance that costs more and you don't have a job. But the idea is that you at least have the opportunity to continue insurance, whether you were let go or you leave employment. The exceptions are if the reason that you were separated from employment was gross misconduct. And your employer has to comply with the provisions of COBRA if they have more than 20 employees. So you guys should be getting the idea. Definitely if one of these situations apply, you'd go to an attorney, have them look at the particular statute and the requirements in terms of number of employers and what other requirements. But I guess the flip side of it is somebody last class said they were pregnant and their husband left the job and was taking on a new job, and they had a 90-day period where they needed insurance, and it was costly, but it was better than not having insurance at all. So, this is also in the new version of the textbook in terms of HIPAA, and there's a number of things in HIPAA, from what information has to remain confidential to your ability to maintain health insurance, in this case employer-sponsored group health plans. So when we talk about employment law, just even in the area of income security, there's a whole lot from health insurance to when we are employed to when we retire. So now let's talk about while we're employed. Employee privacy. Whoops. Remember, privacy is a right not set out in the Constitution specifically, but it emanates from the Constitution. We have that everywhere we go. However, there's not that many areas where we have a reasonable expectation of privacy in our employment. So you might expect that areas in your workplace are private, but others don't. Like if you keep things laying around in your desk, you send email from your personal account over the employer's network. One of the big ones lately has been, I said nasty things about my boss on Facebook.
That's so stupid.
Stupid to do it.
Somebody just wanted them.
Yeah, there was the case where somebody was feeling, it was an argument of whether they had a right to speak freely in a social forum. Was it the NLRB? Was somebody at a labor relations board got involved in it? Yeah, and said that this is collective discussion of, right. That's acceptable, that you should allow your employees to do that. They can meet, like in a union situation, and do it. They can meet around the water cooler and do it. So that's what they were using Facebook for. Still not a good idea. You know, as a lot of those reports say, your employer is usually your friend. Like, you know, if I were to look at my Facebook account and look who my friends are, you know, I use it for family and, you know, sharing things back with my family. But, well, I probably wouldn't be saying things on the internet about my boss. Yeah.
When I got hired into my job, they told us that, like, we can get drug tested if they have suspicion of it. And they said that they can use Facebook if somebody comes in and says, I think the person is smoking pot, even if it's not at work. Like, if somebody sees it on their Facebook with reasonable suspicion, like, oh, I got so blasted last night or something like that, then they can have a drug test for you.
Yeah, I mean, if the pictures that you post are live of you at some
Woodstock affair.
yeah, something, you know, and then minutes later you're at your employer, that might raise some questions. I mean, there's tons of cases about this. Yeah.
The state of Michigan just went public and announced that they understand the social mediums. However, per state of Michigan policy, they are not allowed at work. Whether you're on break, lunch, social media, Facebook, MySpace, you are not to be using them. And when I worked, I just didn't do it at work.
Yeah. Right.
Because regardless of whether I'm on my break, I'm still using their network, their computer.
Not if you're on your phone. Exactly.
But that's different. The problem is they've got people who are working, who are on the company's computers. And yeah, I'm on break, but regardless, you're
yeah,
still...
I mean, part of it is a question of whose network you're using, and even that's subject to, like, I have a phone that has wireless, so now I'm on the wireless network here at work. But part of that is an issue around what you're using, but the other part of it is around the time. And, you know, especially in the government, like, the public thinks that you're getting paid to work for them and not Facebook. So I'm not taking sides in that debate. I've trained faculty on how to use Facebook groups and stuff like that to help facilitate learning. So on one hand, our college is struggling with should the employees be sitting at a desk on Facebook versus doing work, and on the other hand, how could it be used as a tool to communicate? I mean, we've got a fan page for GRCC. Who maintains that? I bet somebody here at the college on college time is posting, you know, events and things that happen. So, yeah.
They just blocked it from the county. At the county, you could
Only
get
certain offices.
And
Still the way around it. Right.
That makes your private information very open to anybody in IT. You're opening that up for them to.
Well, I think that people who don't think their private information is available. Are you saying that if you get on Facebook, your private information would be available, or?
But if you're at work,
right.
Anybody from IT can just go, what's she looking
Even
at, and they can get.
Sure.
Even if you're at home, your private information is not
Well,
private because
to some extent, if you set certain privacy things, and I don't think that the
because
IT people are going to go looking for me, but they could if I'm at work.
No, I'm
start looking.
But like
That's what
anything
I'm
that you
saying.
put on Facebook is just so not private
Oh, I know.
anymore.
I'm just saying.
It's just so it's ridiculous. Like the ads that they put up on the side. I mean, they're geared towards you, which is obviously it's sending your information someplace.
I noticed something even last night. I mean, I'm all about privacy and how Facebook has no privacy. I mean, a lot of people signed up for Facebook because they thought it was a closed community, but it's so. I'm taking a class from Stanford for nothing. I'm not paying for it. It's one of these open classes, and I was taking the class at night. I had it kind of running, and I was doing something, and I paged into Facebook, and I'll be darned if there wasn't an ad on the right for Stanford University. Now, it wasn't me posting anything in Facebook about I love Stanford, it's awesome, it rocks, I'm taking this. I hadn't said anything in Facebook about that. But the browser knew that, yeah. So.
And your cookies, if your cookies on your computer, you go on Facebook and it says, oh, you have a cookie from Stanford. Oh, yep.
Cookies. I'm kind of hungry. Sorry. So, well, we can go on and on about Facebook, and like I will tell you though that since they blocked it in the math computer lab, I can now actually have my exams in there without. I'm telling you, every semester I do my exams in there, and these people, I'll close the door, I'll put a sign up in front of the door that says "exam in session," and like birds hitting the window, man. I gotta check my Facebook. I gotta post something on Facebook. They're zombies running into the glass. I'm like, we're closed. We're giving an exam. Since they turned that off, we're good to go. Right? You can find a computer now. I mean, I see both sides of that argument. Anyway, electronic monitoring goes further than you posted something on Facebook bad about your boss. It may also be. And we could talk about how people use Facebook for hiring decisions and things like that. But also in terms of cameras, listening to phone conversations, recording them, all those different types of things. I mean, a lot of people think cameras are for customers who might steal things. I mean, cameras are for employees who might steal things, or just monitoring your performance. I mean, as the workforce gets more diverse, different locations, supervisors can't look at everybody at one time, so why not have a few cameras on them? I was at the mall this weekend, and I was pointing out to my kids where all the security cameras were. They were amazed. Like if you just actually, Woodland, like even the food court area.
Yeah, I've been into this. I work there.
They're all-
in the security office. Like, I have
They're-
a bunch of friends that are security guards, and so I was just hanging out back there with them one day and just looking at all the different camera angles and like shots that they have. One time they were in the office, and there were these kids that were in the mall during school hours, and they were
Right.
under the influence.
They were
taking
tracking them
property.
everywhere.
They watched them walk out of the mall, across the parking lot, across the East Beltline, and were looking in the windows of the gas station across the street,
That's
looking
crazy.
at them drinking and whatever, and called the police and had them arrested. It was crazy. I was like, oh my god. It was-
So if you're doing anything out in the parking lot,
they
Somebody.
can see everything.
There are blind spots though.
There are, but they use.
Let's not put that on the
other-
recording.
They can use other, like JCPenney has their own separate security, and so they can get into their security system as well as into other stores' security and watch throughout the whole.
But there's still like, and the like thieves know where they are, because one of my friends got his car broken into and contacted the cops and the security and everything like that, and they know that there's a blind spot right there because they're like, we can't do anything because there are no cameras.
all right, well, let's move on. I got a whole lot of stuff to talk about. I don't mean to cut anybody off, but we got to get through this. But this raises privacy concerns. Should your employer tell you that you're being recorded, you're being videotaped? There's also like testing. When you hire somebody for a job, what drug testing. I've had all these tests. I've been polygraphed. I've been DNA tested. I've been drug tested. That's how I lost all my hair. They took my hair out and tested me.
What did polygraph you for?
Yeah, look at me. Look at the way I run my class. You don't know half the time I'm telling the truth or not.
Did they find any drugs?
No, never. At one time, though, I was a state training officer in the military, so I always knew where the drug tests were at.
So you went to detox?
No.
As we record
They did DNA testing just so they would be able to document who I was. HIV testing. But this raises some questions when after you're hired too. Like if you get in an accident, you're going to get screened probably. Immigration law. There it is. One slide. And basically, you've seen in the news how this has become a conflict between the state and federal government. Where it comes up with employers is who you can hire. What kind of background they have. Are they legal or illegal aliens? And I'm going to skip that and tell you that there's not a question on the final or the practical exercise about it. Title VII. You've probably heard of that before. Title VII prohibits discrimination based on those categories. So, a hint to you in the future, if it's not one of these categories, it's not under Title VII. Race, sex, color, religion, national origin. I mean, it could be another type of prohibited discrimination like age. We'll get to the Age Discrimination Act. These slides are from the publisher. I didn't write the next sentence. Sex now includes pregnancy.
Could you explain?
You need me to explain that to you? That actually means gender. So, if you discriminate against somebody who's pregnant, then you are discriminating based on gender. Because so far, contrary to some claims, only one gender has been able to get pregnant.
Please don't know about
It's just an odd sentence. It says sex now includes pregnancy. That's pretty much how it happens. But it's talking about if you discriminate against somebody because they're pregnant, you are discriminating based on age. Yeah. Well, I guess there's that. Or maybe you're a virtual person. All right. And just we'll get into religion a little more here in subsequent slides, but it's not just in hiring. It also can be in terms of reasonable accommodations you make after somebody's employed. And there's lots of cases about what's reasonable or not. And Title VII is enforced under the Equal Employment Opportunity Commission Act by the EEOC. If you want to learn more, you can follow that link. Now, here's a biggie for people. Discrimination could be intentional or unintentional. A lot of people think you can only be held responsible for discrimination if you can prove somebody intentionally discriminated. But discrimination, intentional or not, in those areas I just mentioned, is unlawful. If it's intentional, it's called disparate treatment. You make out a prima facie case, that means on its face, when you're able to establish you're a member of one of those protected categories we mentioned. You applied for, were qualified for, and were rejected from the job, and you went on to seek employment somewhere else. Once you establish this prima facie case, these things, then the burden switches to the employer to say, no, this is why we did what we did. I think the next check mark there at the bottom is supposed to say non-protected applicant. So in unintentional discrimination or disparate impact, basically what you're saying is you didn't discriminate intentionally based on something like race, but as you look at the workforce, it appears that the impact of your practices are discriminatory. So there's only one gender, there's only one race. Something is going on. And then the burden is on the employer to explain a reason for that. Yeah?
Doesn't it seem like they could just continue to just come up with any reason not to hire somebody?
Well, not any reason isn't always going to fly with the statute or the court. So we had a discussion in the last class. Can an employer discriminate because you don't fit their mold? Like you're not arguing it's based on gender or one of these other categories. You're just you don't have the right look. Like I went into this weekend, I was looking for a little extra money. I went into Abercrombie. They took one look at me and my age, my hair, my abs, and they said, no, you're not going to work here. This is discrimination, right? Well, they're looking for a certain kind of person. They are discriminating, right? But the question is it illegal discrimination? Well, if I was going to bring a claim, I wouldn't say they discriminated me because I didn't look quite right with my shirt off. I'd probably say it was based on age or something else. Right? So usually it's not neat and tidy one thing. It's usually a number of things. If you want to fall under Title VII, you might have to Be creative in terms of your claim. And then the flip side of that, reverse discrimination. Sometimes employers, in an attempt to undo past discrimination, will discriminate. At least that's the argument. So if somebody is accused of racial discrimination, they might try to hire more of another race in the workplace. Well, then somebody's going to argue that that, in fact, directing your hiring practice at a particular race is discrimination. There's lots of cases. U of M had a big case about that. A number of big cases about that. Discrimination based on religion, I already mentioned accommodation. Just add the last part of that, in that you have to make reasonable accommodations for sincerely held religious practices if they don't cause an undue hardship on the employer. In fact, that's true of like even the ADA. You know, if you have to tear a building down, rebuild it, that's probably an undue hardship. So a lot of these things are reasonable accommodations, which again, don't ask me what those are. The court's going to determine what that is. And then gender, and you know, it's certainly true that even though there are laws related to not having gender discrimination, that men and women get paid differently. But sometimes employers can explain these things in other ways. There's another reason for these things, which we're going to get to. The last bullet up there talks about constructive discharge. The fact that, well, maybe you weren't fired, but the environment that you were in, or the fact that you might as well have been discharged. You know, here's an example: sexual harassment. Somebody may not say, "Do this for me, or I'll fire you," but they might create a climate or environment that it's hostile to work there. So the Supreme Court has interpreted Title VII to include everything from same-sex harassment to a couple of different forms of sexual harassment. Hostile work environment be what you see, what you're subjected to in the work environment. Quid pro quo means this for that. You know, that somebody says, if you do this for me, then I will promote you or treat you favorably. So, I mean, this pretty much goes into detail about what a hostile work environment. But think about that in the context of what we were talking about earlier, Facebook. You know, pictures that are posted, emails that are sent, what's on your computer screen. There's a lot of potential issues there. Safe thing, don't ever communicate or display something that would be harassing. So the only thing I'll say about this is just that you need to have a policy letting your employees know what to do if they feel they're being sexually harassed. The policy also needs to address what if it's the supervisor that's doing it. In other words, your policy can't just say, go to your supervisor if you are being sexually harassed, because in some cases it might be the supervisor. So folks have put themselves in, you know, if part of it is this for that sexual harassment, then you have to have another way around it if supervisor is the issue. And I'm going to skip the rest of this. Other than it could be another employee, not necessarily your supervisor. Or there have been some cases around whether it's not an employee at all. Maybe it's a customer. My last class got off track there and wanted to talk about situations where customers might harass employees due to the nature of the work. I had to get them back on track too. All right, remedies under Title VII. So if you successfully recover for a violation of Title VII, you could get your job back. You could get back pay for when you didn't have your job. Maybe a retroactive promotion. You would have been promoted if you had been able to keep your job. Or whatever that job was you were going to get promoted for, but got fired instead. And damages. Then age-based discrimination. I asked one of my classes, why 40? They said, because you're dirt old when you're 40. I did. I flunked every one of them. 40 probably because at that point the worker gets more expensive to pay. Sometimes it's health questions. Sometimes it's because they're vested and they're going to have to pay out something. Sometimes it's this. It's just a lot cheaper to pay younger employees. So basically, same thing. Show you're within that age group, you're qualified, and you got discharged. And then the burden shifts to the employer. I'm going to skip all these slides on. All right, disability. Probably heard of the ADA before. Employers need to make reasonable accommodations for those that have a disability. Disability is defined not by you, but by the Act. And basically, you'd have to show you have a disability under the Act, you're qualified, you're excluded from employment, or your employer didn't make reasonable accommodations, and the workforce has to have more than 15 employees. All right. And that you exhaust your administrative remedies before you go any further. So I'm going to skip the slides that have to do with going into detail about what is a disability. And I'm going to jump down to defenses. So, this is the employer side. And this is just making the argument that there's some reason why you have to discriminate. Now, for some things, there's not good reasons. Like race, there's usually not a good reason to discriminate based on that. What if you need a male model or a female model? Well, then you're going to discriminate based on gender. BFOQ, bona fide occupational qualification. You can't teach in seminary without having the necessary background. They don't want you teaching there if you don't agree with it. So when I got hired here at GRCC, they had a whole different set of questions than when they hired me at Cornerstone University to teach. It was okay for them to ask me that. It's not okay for them to ask me that here. It's not an occupational qualification.
You're an atheist, you can't teach at Cornerstone.
They don't want you teaching that there. Although there's been some things in Cornerstone about what jobs you have to have that requirement in. Seniority system. Maybe it's not because you're gender or whatever. Instead it's because of a legitimate seniority system. You had more time in than another, and that's why they were treated differently. And then finally, after acquired evidence, sometimes in this type of litigation it comes out that maybe the employee committed misconduct. That doesn't excuse the employer's discrimination.